1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ် 9 ဒေါ်မြတ်မေ and Company Plaintiff vs Saint Thorn and Phetan Company and two others defendants ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Regular before ဦးသက်ဖေ Judge ဒေါ်မြတ်မေ and Company Plaintiff vs Saint Thorn and Phetan Company and two others defendants Civil Procedure Code Order 38 Rule 5 and 6 Task for furnishing security or in default attachment before judgment in a promissory note suit held the jurisdiction of the court to attach the defendant's property before the rights of the parties are finally adjudicated upon is extraordinary and urgent in nature. One useful test to justify for adoption of such a course is whether the plaintiff would suffer an irreparable injury unless the order asked for is granted and that the mischief of inconvenience which is likely to arise in consequence of withholding the relief will be greater than that from granting it. The mere apprehension of the plaintiff that their dues might remain unpaid without any concrete evidence is not a ground for calling upon the defendants to furnish security, much less to order the attachment before judgment. Held further, the words used in Rule 5, Order 38 of the Civil Procedure Code indicate that it applies to cases where the defendants are about to dispose of their properties, not in case of completed transaction. Hari Bharkash vs. Babule and another AIR 1928 Lahore page 772 Bidanan Rai and others vs. Nabokuma Singh and others AIR 1938 Patna page 161 refer to Ubashon for the plaintiff Mr. V. Sansi Bo for the defendants. Udape Judge, this is an application under Order 38, Rules 5 and 6 of the Civil Procedure Code to direct the defendants to furnish security and in default to attach before judgment 3 pieces of land with 3 modern cottages and 1 3-storied pucca building standing thereon, valued at 300,000 belonging to the defendants. The plaintiff, who had sued the defendants for recovery of debt 69,500 said to be due on a promissory note, alleged that the defendants are not possessed of any property other than those mentioned above, which they had given in mortgage to the State Commercial Bank, and that they had sold 2 acres out of 8 acres from one item of mortgaged lands, which would go to show that they are bent on disposing the properties with the permission of the mortgagees and utilizing the proceeds for their own benefit, thereby would deprive the plaintiff of the fruit of the decree, which they might eventually obtain in the present suit. It is true that the defendants had mortgaged their properties with the State Commercial Bank, which had filed a suit against them for recovery of debt 142,037 jet in civil regular suit number 24 of 1964 of this court. The properties are admittedly on the own showing of the plaintiff, worth not less than jet 300,000, whichever after deducting the mortgage debt due to the State Commercial Bank is more than sufficient to cover the claim of the plaintiff. The sale of 2 acres out of 8 acres from one piece of land by the defendants would not reduce the total value of the properties to such an extent as to prejudice the plaintiff's claim. The jurisdiction of the court to attach the defendant's property before the rights of the parties are finally adjudicated upon is extraordinary and urgent in nature. One useful test to justify for adoption of such a course is whether the plaintiff would suffer an irreparable injury unless the order asked for is granted and that the mischief or inconvenience which is likely to arise in consequence of withholding the relief will be greater than that from granting it. The present application was made as early as 30 October 1964, and it cannot, at the time of hearing, which took place on the 3 January 1966, be seriously contended by the plaintiff that the defendants are in that period of more than 1 year contemplating to dispose of or negotiating the disposal of their properties, and that there exists the real fear of a grave danger that the defendants are dishonestly trying to cheat the probable fruits of the judgment. They could only stress about the sale by the defendants of 2 acres out of 8 acres in one piece of land, which as pointed above is not likely to affect the claim of the plaintiff. The mere apprehension of the plaintiff that their dues might remain unpaid without any concrete evidence is not a ground for calling upon the defendants to furnish security, much less to order the attachment before judgment. Besides, the words used in Rule 5, Order 38 of the Civil Procedure Code indicate that it applies to cases where the defendants are about to dispose of their properties, not in case of completed transaction. It appears from the reply of the State Commercial Bank in Civil Regular number 24 of 1964 of this court that the defendants had paid the sale proceeds of 2 acres of land amounting to jet 15,000 on the 29th of January 1964, which was much earlier than the date of this application, namely 30 October 1964. Thus, it has been ruled in Hari Bakash vs. Babule and another one that Rule 5 contemplates attachment of property which the defendant is about to dispose of or remove from the jurisdiction of the court and not of the property already disposed of. In Bidanan Rai and others versus Naboguma Singh, plaintiff and others too, it was observed that before the provisions of Rule 5 of Order 38 could come into play, the court has to be satisfied that transfers were going to be made by the defendant after the suit had been filed and that such transfers were with the object of obstructing the plaintiff if he won the suit in executing the decree, and mirror allegations to this effect are of no avail, but the facts must be positively proved by satisfactory evidence. Even assuming that the defendants had sold 2 acres out of 8 acres in one piece of land after the institution of the suit, it was done in order to pay up part of the mortgage debt due to the State Commercial Bank. There is nothing to suggest that the disposal was made with intent to obstruct or delay the execution of any decree that may be passed in favor of the plaintiffs. In this connection, it will be relevant to refer to the decision in Naoroji Pudamji Sirador versus the Deccan Bank Limited 3, where it was held that merely because the defendant attempts to sell some of his immovable property while proceeding against him are pending, it does not follow that he is disposing of the property with intent to obstruct or delay the execution of any decree that may be passed in the suit. Lastly, I would respectfully adopt the observation of Lord William Judge in Dhaka versus Nalin Chandra Nandan and others for which reads, finally, neither injunction nor attachment ought to be lightly granted. It would be a serious thing if persons in possession were restrained from making use of the property merely because a suit had been instituted about it. It is only where it is essential that property should be kept in its existing condition pending suit that the court should interfere. In the result, the application of the plaintiff under Order 38, Rules 5 and 6 of the Civil Procedure Code fails and is dismissed. In the circumstances of the case, there will be no order as to cause